But here's the thing, sometimes there have to be consequences.
This one is going to come down to whether the story holds up. The defendant is going to explain why she thinks she deserves a second chance, but the court is going to look at everything that leads up to this point. So pay attention to how that unfolds. My name is Dan. This is the Courtroom Files, and apparently Ellie's going to watch too.
Let's go back to Judge Elmore, new contestant.
Saki. Our next our next case this morning is People of the State of Michigan versus Kelsey Jackman Sims. File number is 25-3596FH. Appearances, please.
Your Honor, David Inhofe on behalf of the people.
Michael Horowitz on behalf of Ms. Sims.
Ms. Sims is currently in custody at the Missaukee County Jail, serving a sentence. The court issued a sentence back on December 12th of 2025. The court sentenced her to 330 days. That was for a count of possession of a non-narcotic controlled substance. And she, one moment. How long did they put her in supervision for, Ms. Odell?
It was a jail only sentence.
Jail only sentence, yep, okay. By the way, Ms. Laura Odell is here from the Department of Corrections. Why are we on the record today? We're on the record because the defendant has filed a motion to this court pursuant to MCL 801.257 and relief from judgment as well under 6.502. The MCL statute that I referenced has to do with the court's ability to release someone early. I'm going to turn it over now to Mr. Horowitz. Mr. Horowitz.
Good morning, Your Honor. Thank you. I do have two documents that I would like to the court to receive. I don't have copies of them. I just received them this morning.
Okay.
The other 5 documents that I provided, I also provided to Mr. Denham by email. These two, one is a certificate of participation from Catholic Human Services dated 4/16.
Okay.
Okay, and the other is a letter from Ms. Sims' mom, Joyce Parnell, who's present here. And in addition to the people that placed appearances, Your Honor, there are, I believe, 4 individuals in the courtroom today on Ms. Sims' behalf. That's her mother, her aunt, a representative from CMH, and a representative from CHS.
Yep, I recognize the members from CHS and CMH. Also, the court's going to receive those. Did you take a look at those, Mr. Denham?
I did. No objection. The court's receiving.
All right, thank you. Before I take a look at those additional items, the court also received earlier this week a couple other documents from Mr. Horowitz. One is from CMH, specifically the social worker, Ms. Van Houten. I did review that. And the next is a letter from Ms. Platts. Also, again, she's the person from CA, Catholic Human Services that we mentioned. I also have a letter from the Sunrise Treatment and Recovery Center. There's an intake coordinator there stating in the letter that there is availability for Ms. Sims to enter a treatment program on August 20th. There's also an email from a person whose last name is Picard, and that would be the aunt that Mr. Horowitz mentioned. And a friend of hers sent an email, and that is Cody Harold. And I did review those actually yesterday. Okay. Now, with a quick look, again, I have a certificate of participation in Catholic Human Services. Well, it's one of the 2 documents Mr. Horowitz provided. Now let me take a quick look at this other letter, and this is the one that is from Ms. Sims's mother. All right, I've read that. Anything else factually you wish to present to me, Mr. Horowitz?
Your Honor, I think most of what I need to say is in the motion itself. Of course, these are kind of unusual requests to make to Your Honor. I know they're provided by court rule and by statute. That said, I think the court probably doesn't see a ton of them. Usually, when the court imposes a sentence, the court has imposed a sentence, and that's the end of the story. However, the legislature has recognized that or given courts the authority and discretion to revisit a sentence if the court feels that the person has excelled in certain ways while in custody. So a lot of the conversations or letters that I had initially received about Ms. Sims were kind of about, her background or about the things that she had been through. And I really tried to distinguish to Ms. Sims and to the letter writers that what we're looking at is we're only really concerned with post-sentencing behavior, conformity, conduct, because Your Honor already considered all that other stuff in imposing it, in imposing the court sentence, right? So you were given pre-sentence investigatory guidance through MDOC probation. You were given arguments of counsel. And so you should, to the extent that those things were relevant, be aware of Ms. Sims' background, obviously criminal history, struggles, trauma, so on and so forth. So that's already, I guess, baked into the sentence. So that's not the point. The point is that since being sentenced, the people in Ms. Sims's life that she has contact with have indicated to me or to the court that they have witnessed or observed significant change in her demeanor, in her behavior, in her motivations to do better. She is also engaged in non-mandatory voluntary services involving substance abuse, rehabilitation, and personal therapy, personal psychological issues, and has been engaging in those things positively. She's also reached out to the outside and secured a bed or place or just, I guess, whatever with respect to the inpatient counseling. And so I think that she's demonstrated that she's really taken a lot of the court sentence to heart and has benefited from it, and that she probably doesn't need to have continued incarceration. And of course, it's a big ask, but I think she's given you a lot more information that didn't exist at the time of sentencing. That said, I will note that the people did file yesterday the evidence of the 2 infractions that Ms. Sims has had, or marked write-ups, whatever they're called, while in custody. And at least the second of those, to me, which I didn't identify because I believe it happened maybe after I had conversations about writing the motion, is probably more troubling than the first. The first, if Your Honor is familiar with it, there was an indication that the inmates were "quote unquote" exposing themselves. This was not the height of criminal behavior, my understanding, and the court could address Ms. Sims about this or just accept my representations, is that female inmates were comparing breasts. There was no ill will or criminality. It's embarrassing. I get it. Sorry. But that's the context there. The second, as to the misuse of the prescription medication, really the sort of I don't know if it's a mitigating factor of that, but is that I believe that Ms. Sims disclosed that. She admitted and acknowledged that to the jail in a way of saying, I need to be off of this. I need to not have access to this medication, is my understanding. And that may not be fully accurate, but that's just the gist I got. So the medication in question, I believe, is Visceral, which was an it's an antihistamine that's also used off-label for anxiety or something like that. Nothing that I'm particularly familiar with, but it's my understanding that she disclosed that misuse and just wanted not to have access to it anymore. So that said, I think she's given you pretty good documentation of what she's been up to and why you should consider reducing her sentence, at least to some extent. And I believe that Ms. Sims also has a letter or prepared statement that she'd like to make here.
Thank you. I'll turn to Ms. Sims in just a moment. Mr. Denhouse.
Thank you, Your Honor. Some of the things I'm about to say are somewhat negative, so I want to start out positive. Certainly, the people support every effort that Ms. Sims is making towards sobriety. And we do appreciate the fact that apparently she's been attending Catholic Human Services as well as community mental health. Certainly supports those efforts. In reviewing, the file for this hearing, I did look at the transcript. I made note of the sentencing. Obviously, as has been referenced, there was no probation because of the defendant's conduct on bond. The court had indicated in the transcript, page 17, that every opportunity of grace has been provided to you. Essentially, what had occurred in this case is that the defendant was AWOL for several months. There were no less than 3 treatment facilities that she went to and left. One of which was the Sunrise, the one that the defendant is now seeking to be admitted to again. And there were 2 sentencings that have been scheduled that the defendant failed to appear for the sentencing. So that's some of the background. I think that the court's reasoning at sentencing was appropriate. We submitted the incident reports just to give the court some context. And we would take the position that the court's prior sentence was appropriate. And with that, we'll leave it to the court here.
All right, thank you. Yes, Ms. Sims, is there anything you wish to say at this time?
Yes, Your Honor. I wrote some things down this morning because I'm not good at public
Okay.
speaking.
And you may sit down if it's more comfortable for
Okay.
you.
Your Honor, I stand here today before you, a changed person. I've learned humility and a priceless life lesson, and I have to thank you for it. At the beginning of this, when I was arrested back in November, I thought everyone else was the problem and to blame for my actions. I wasn't taking accountability. I come before you this morning after spending the past 5 months in jail, changed, experiencing growth, and taking full accountability and acknowledging I've been the biggest problem in my life, nobody else. Going to groups with Nikki from CHS helped to plant that seed, so I'd like to take the time to thank her right now as well. Thank you. Since completing her 10-week course here in jail, I've decided to make some more positive choices. If you so choose to extend me the grace, I've decided to go back to inpatient rehab and do it for me this time. I've never done that. And attend sober living after. I've already been approved and have a bed waiting at Sunrise Center. I want to do better and be better. I'm extremely remorseful for my actions and how I have behaved. I can guarantee you, Your Honor, I'll be doing everything I can to never have to be in these circumstances ever again. I've sincerely learned my lesson, and I'm asking you to please consider granting either motion so I can continue on with bettering my life and proving that I've changed. Thank you.
Thank you. All right. I remember this well because it took us a lot of effort to get the case done. Because Ms. Sims was impossible to supervise on bond, right? It took us like 7 months, if I recall, from the date of the filing of the felony complaint to district court until we can get it resolved in circuit court. And I specifically remember this because I wrote it on my copy of the PSI. And it said, no drugs, question mark. There's a page inside these pre-sentence investigation reports. It's called CFJ 145, page 1, and there should be at the bottom a list of drug substances and use issues. Didn't appear. Then when I look back in the section of that report, CFJ 284, and we get beyond the criminal history, and we get to a portion about substance use and treatment. There it said defendant acknowledged using marijuana at the age of 10, and then alcohol, and then cocaine at the age of 12. And then it went to methadone at the age of 18, and then made several attempts at treatment, including 3 attempts that we gave her back in last year, 11 months ago. She gave a statement that she was confident that she could complete any current inpatient treatment program. So what I didn't see in there is any section that described her drug history very well. Typically, at drugs, it shows dates of start and dates of end. Well, what's missing here is a complete picture. It says methadone at the age of 18. Hold on. Well, she didn't mention that when she was 22, she got convicted of morphine. She also did not mention during her history, and it took going through her prior criminal history and her performances on bond and probation, she forgot that at the age of 28, her using methamphetamine. And then there was another use where her child apparently tested positive for methamphetamine. But still, I didn't see any references to that in her description and admission about substance use. So I remember exactly this case because I thought to myself, she wasn't upfront about her drug use. She said, oh my gosh, I'm just being convicted because they found one of my dog's pills. And she wouldn't do treatment. She has violated bond so many times. I went very thoroughly over her criminal history. I talked about the short gaps in time between convictions. I talked extensively about her probation violations, her bond violations. In 2010, she had one case where it was just an attempted retail fraud, and she had to have a bench warrant one time. Then she had 1, 2, 3, 4 probation violations. And those all began 2 weeks after she was sentenced. Then in 2013, when she got the use of morphine, she had another probation violation. And that probation violation came only 4 months after being sentenced, having just gotten out of jail. And then in 2016, there were multiple probation violations on the larceny in a building, and her probation, had to be extended. By the way, while that case was pending, she violated bond within 2 months of being on bond for one felony and picking up another felony. 2018, that case, she got convicted while on probation, and she had probation violations that began 2 months into her 6-month probation period. 2023, she was on probation when she picked up another charge. That one was for domestic violence. But she did make it about a year and like 5 months until she fixed up the charges for which she was convicted here. And actually, the offense date was December 4th of 2024. And the arrest date was December 7th, 2024. And because we kept giving her efforts, which she decided to thwart, because, hey, she doesn't mention all of the drug history, and this was just a dog's pill. So when she went into the jail, the reason why I didn't give her probation was because she was confessing that she didn't have a problem. Why did you thwart all those other efforts?
I wasn't taking accountability, Your Honor.
Yeah, I know, that's everything I'm saying. This whole PSI that you gave was an absolute farce.
The past 5 months, I've come out of the fog from using
Yeah.
all them years, and I realize the mistakes that I've made.
Yeah. What credit does she have, Miss Odell? So she had 35 days, I think, initially. So now she's up to 90. So hold on, wait. Should be somewhere around 120.
It's like 138.
You know, I see Miss Odell's got her handy dandy cell phone out. You just do I call
Handy
it,
dandy date calculator.
yeah,
12/12 of 25 to present.
yeah, plus 35. Here she got the credit, 35 days of credit, I think is what it was. Yeah, 35.
$126 days
Okay,
plus the 35.
plus the 35, so yeah, 162 days. That sends her to 330. So 275, so right now she's got another 120 days left to serve if she gets all of her good conduct time. So I've got one question about the statute. Just give me a minute. Put that in our book. 801, what is it? 801 2 or 623 or something.
801257.
I wasn't even close with that last three. Oh, it's probably easier if I pull it up on my phone. So please, no one think that I'm you texting in a second. What was that again? 5,
801257.
2, 5, 7. Oops, I did it.
Any success, Your Honor, I have it in front.
Yeah, I've got it. Thank you. Yeah, see, I remember it being a very short statute as far as length. And it does just simply say that a prisoner or an inmate in a county jail may receive, if approved by the court, a reduction of 1/4 of his or her term if his or her conduct, diligence, and general attitude merit her reduction. Well, we've got some merit, and that is she's doing some treatment there in the jail, which is great. By the way, she has to. Therefore, whenever we've let her try to go do it on her own, she took off running. So here's my thought process, and I know what my ruling is going to be, but here's how I get there. I can't amend a lawful sentence. That's what the court rules say. I lose jurisdiction of the sentence once I issue it, except when a statute like 801.257 allows me to come back and review it. But I'm only able to review it as to the amount of days that she's confined for the period. And that's my problem. Statute doesn't allow me to go back and give her probation because there is no way I trust that Miss Sims will go do the program unless she has a hammer over her head. And the only way I could have a hammer is if I have probation. But at the last time we were in court, she had demonstrated so thoroughly that there was no way she was going to comply. And I just said, no, I'm not putting you on that because you've told me you don't have a drug problem, that this was accidentally a dog's pill in your bag or purse. So I gave you no probation. I cannot, pursuant to that statute, give you probation. I furthermore cannot, pursuant to the court rules, amend a lawful sentence, which means I can't add probation. And because I will not let you go to a program, because I have no ability to supervise you, you can go to the program when you're done serving your 330 days minus your good conduct time. Because at least I know there, not really that I observe you, I've got no idea, I don't watch cameras or anything. By the way, apparently according to one of these, I'm glad I didn't, but there, I've got people that are doing good things for you. I think the world of Ms. Platts and Catholic Human Services and CMH and the services they are able to provide. Therefore, I'm going to let you still get their benefit. Thank God we are able to use opioid funding money and MRE money to get Catholic Human Services into the jail. And then when you get out, hopefully you never come back to the courtroom here. Because if you do, and you do not leave this jail service and go get that treatment, I will remember this conversation today. And then I'll say, well, I thought you could go do it on your own. So I hope you do. I really do. And I would, if that law allowed me, if the law did allow me to amend a lawful sentence, other than the reduction of the 25%. But it doesn't. And I don't trust that you're going to go do the program. So I'm not going to give you 150 some days or whatever it is for you to maybe go do it. Yes, ma'am.
If it was reduced by 1/4, I still wouldn't get out until the end of May. I still have another month.
I know, but here's the reason. My sentence was lawful and you are still having a problem because as of a month ago, you were snorting your own meds. You aren't and so when I look at even that statute, while you're doing some good, you're not doing enough good because you're also snorting your prescription meds and a histamine. So that counteracts, so that basically balances the two out. And your performance before, when I sentenced you, was enough to tell me and to tell me that the sentence I gave was spot on. You had reasonable ground. You gave me so much reasonable grounds to give you a jail sentence, despite that it's a maximum of 2 years and that it is an intermediate sanction cell. Had you ever taken advantage of any of the opportunity that we gave you, it'd be different. Yes, ma'am.
I was on heavy drugs at the time. I'm not the same person.
I know.
Like I want this more than anything.
I want you to have it too, but I can't do it where I know that I can make you do it.
What about even with a tether?
I can't. I can't amend a lawful sentence unless otherwise specified and permitted by law. The statute that we've talked about today does permit me by law to reduce the jail period,
Correct.
but doesn't allow me to modify and add probation.
Would you consider reducing it?
I'm not going to, because I know at least there, Miss Platts is gonna help you. She's gonna continue to do a fantastic job for you. I have zero doubt.
I've completed her.
I know, well. Yeah, but I think there's always extra stuff there, okay? And Miss Platts isn't gonna go, well, I already gave you a certificate. You can't come back here.
Right.
So, Miss Sims, I want you to get better. I really do. But here's the thing, sometimes there have to be consequences. And you're snorting your prescription meds. So the answer is no. Therefore, the court respectfully, and I do appreciate Mr. Horowitz's effort here. He does a heck of a job every time he comes in. And I'm not just trying to suck up to him, because he does, he puts on a good effort, and I appreciate people who do well. But next time, no, I mean,
Next time.
you, I hope, I really do. I truly, Miss Sims, want you to get out after serving your time. I want you to continue with this pursuit. And I want you to get that treatment. And then I want someday you come, stop by, knock on the door, come sit here in court and tell me, hey, Judge, just to let you know, I did what I said I was going to do. I will be happy. Then if we have coffee, I'll get coffee with you. All right.
Judge, may I
Yeah.
just add one thing?
Sure.
And I don't want to belabor it, and I
I know.
certainly don't want
It's
to
okay.
argue, but I would just suggest, Your Honor, that you could consider kind of the traditional statutory construction that we are generally able to construe a statute's meaning and scope and authority in such a way as to give the legislature's words effect, right?
Yeah.
And so I think that I agree that this is a very, not so much narrow, but sparse statute that doesn't give much guidance.
It's short.
It's extremely short. There's like one operative sentence, right?
Yep.
I think that you could construe that it's in such a way as to give it effect by saying that the legislature is recognizing or vesting in you the ability to reduce the sentence by up to 1/4. But I don't think that the legislature would want to limit the tools in your toolbox, so to speak, as to give that effect. So I think that the legislature would likely not take issue with attaching some other monitoring or rehabilitative measures to that reduction.
I appreciate it. I chuckled, and I'm sorry, I didn't mean to disrespect to
None
Miss Sims or Mr. Horowitz, because no, I see the legislature all the time trying to take away and whittle down my discretion and take it away. So I don't give them any benefit of what they're, unless their words specifically say it, because if I do exercise anything thinking I've interpreted their legislative language and they don't like it, they will swat me hard with an appeal. So nope, I don't give them any such leverage or interpretation, because they don't give it to me. They want to limit trial court judicial discretion. Plus, again, I also know that the court rule, which is also comes down not merely from the legislature, but also from the Supreme Court, does not allow me to amend a lawful sentence. So therefore, I would have to not only disagree with the legislature, but I'd have to disagree with the Michigan Supreme Court. And I can't do that. So, all right, thank you. We're adjourned. Mr. Horowitz, there's an order already inside the file. Yep. There's your.
At some point, it comes down to whether or not the words match the record. Judge Elmore made it pretty clear what he thought about that, but I'm curious what you think. So take a moment now and let me know down in the comments. And if you enjoyed this video, check out one of the two that are on your screen right now. Thanks for watching.